Okay, I think we can start. Allora, are we ready to start? Yep. Nothing there. Well, good morning. We have two speakers this morning. Flora Harragin, who is from Flora and Co. She's going to introduce herself and what she does. She's a family law expert in an excellent law firm in London, and Jorge Marfil, who's been practicing for 40 years and is a lawyer and has particular expertise in, I read, applied genetics and surrogacy as well in Spain. So over to you.
Good morning, everyone. Looking around, I've met many of you over the last couple of days, but I'm still seeing some unfamiliar faces. So for those I haven't met, my name's Flora Harragin. I am a family law specialist in London. I work at a firm called Flora & Co., who the firm's been around since 1701, so it's an old firm, and we have concentrated on private client work, but over the years our corporate team has developed to support our private clients. My practice is primarily focused on dealing with divorce and resolving the finances associated with a divorce or separation, but I also deal with children matters and agreements, so pre- and post-nuptial agreements, and also cohabitation agreements and separation agreements. I must fess up early on that I haven't, in fact, the firm hasn't done a lot of surrogacy work in the past, but that is principally because there hasn't been a lot of that work around. But in the last few years, that has really changed, and we have, in the last year, done a few cases, and I expect that we will do a lot more in the coming years. So I think I will speak first, and then I will hand over to Jorge, who will speak afterwards. What do we mean by surrogacy, first of all? Because I'm not sure of the Spanish translation, but I have mentioned the word surrogacy quite a few times and had some very blank faces. So what we mean is when a woman carries and gives birth to a baby for another person or couple. And what we really want to know is it lawful? And in the UK, which is different to the position in Spain, I know, it is lawful. And surrogacy agreements are legal in the UK. But it is a very technical area, and it's important for those embarking upon surrogacy arrangements to understand fully the limitations and the requirements of the current law. I say the current law because there are proposals for reform, which we will, I think, come back to at the end. But in general, just so you are aware, work started in, I think it was May 2018, and the Law Commission of England and Wales and the Scottish Law Commission, because they are working on the project jointly, intend to produce a report with proposals for reform in, I believe, 2021. So, surrogacy arrangements are legal in the UK, but the first really important point to note is that although they are legal, they are not enforceable. So they will therefore rely on the goodwill of all of the parties concerned, and the court can't make an order against the wishes of the surrogate. It's also important to note that it is illegal to negotiate surrogacy agreements on a commercial basis. So any person negotiating an arrangement, excluding the surrogate or the intended parent or parents will be guilty of an offence, and that, of course, includes a solicitor. It is also illegal to advertise either for or as a surrogate. So, before moving on to discuss surrogacy in more detail, we must understand the way in which the UK law deals with parentage. In the UK, a child can only have two parents, and the legislation provides that the surrogate birth mother, so obviously the woman who carries the child and physically gives birth to the child, will always be the child's legal mother until an order of the court is obtained. Not only that, but if the surrogate mother is married, then her spouse will also be the child's second parent. And that is the case regardless of who the genetic parents are. If the surrogate birth mother is not married, then the genetic father can be recognised as the legal father. So, if the intended parents, we call them intended parents, sometimes I think they are referred to as the commissioning parents, but if the intended parents are to be recognised by the law as the child's parents, and acquire, of course, importantly, all of the rights and responsibilities that are associated with that, they must apply to the court for what we call a parental order. If they don't, and if a parental order is not made, then the child remains the legal responsibility of the surrogate mother and the father if the surrogate mother is married. So just kind of pausing for thought there, it's important to make you all aware that only a small percentage of parents who have children born through surrogacy actually obtain the parental order. I don't have more recent figures, but our court in 2015, our court only dealt with 241 applications, and that is compared to 2,000 births, which we understand births to surrogate in that year. So 241 versus 2,000 births. So obviously that's quite a worrying statistic, because there will be many who are considered by their child and others as parents, but the law would not regard them as parents. And without a parental order, there are also those women who consider themselves to be, or don't consider themselves to be the mother of the child, but the law would consider them legally responsible. So that really does highlight one principal area which calls out for reform, and that is something that the law commissions are looking at, and we'll come back to later. So let's look at parental orders in a little bit more detail. A parental order makes, as I've put there, I've set out in the slide, a parental order makes the intended parent or parents the legal parents of the child and permanently extinguishes the parenthood of the surrogate and her spouse. I go on to say, the child will then be treated as the child of the parties from the date of his or her birth, not simply the date of the parental order, and the birth certificate will be reissued. That's important and significant, especially when you look across to adoption law, because in adoption, parental status only takes effect from the date of the adoption order. So we have a slight difference here. As I've put, the original birth certificate will be sealed and will be accessible to the child once he or she is over 18. And speaking to Miriam earlier this morning, we could go into a lot more detail about what the child and when the child will be entitled to such information. And if we have time, we'll come back to that at the end. But as I say, the original birth certificate will be available to them once they are 18. It's also a very important point that until very recently, it was only couples that could apply for a parental order. The law was changed, and from earlier this year, from January this year, single parents can now apply for a parental order. Okay, so when will the court make a parental order? The requirements are all set out in the legislation, and perhaps inevitably there are quite a few hurdles that need to be surmounted. For this reason, it's really, really important that parents thinking about surrogacy take advice at a very, very early stage. And we'll come on to now the conditions that need to be satisfied, but it remains that the court must have the best interests of the child at its heart, and that will be the paramount consideration. So case law has demonstrated over the last few years that even if the intended parents fall short in relation to some of the conditions, the court is likely to want to make the parental order. And that is another reason why there is need for reform, because the case law is tending to do, or perhaps to go further than the law is currently providing for. So looking at some of the specific requirements, the conception must have taken place by embryo transfer or artificial insemination, and the child must then have been carried by a surrogate. The intended parent, or if they are a couple, at least one of them, must be the child's biological parent. Again, that is something that the law commissions are looking at and considering, whether it should be necessary for one of the parents to be a biological parent. There are then various other conditions that need to be satisfied. If the intended parents are applying as a couple, and of course, as I've said, from January this year, you can apply as a single person. If they are applying as a couple, they must be married, civil partners, or living together as partners in an enduring family relationship. There's also a time limit. The intended parents must submit the application to the court within the 6 months after their child is born. But note here that the court has, in very many cases, made a parental order when the parents have applied outside of that time limit. And really that is because, as I've said before, it must have the child's welfare as the paramount consideration. And at that stage, the child will be living with the intended parents, and it will consider that, its hands are tied and it is in the child's best interest to make that order, even if the parents have submitted the application outside of that 6-month window. At the date the intended parents apply for the order and the date the order is made, the child must have his or her home with the intended parents. Again, case law has interpreted that widely, and an order has been made in situations where the parents are actually living separately and the child is moving between the two homes. Moving on then to the next. Don't know if that's stuck. So, at the date they apply, the date of the order, the intended parent or one of them must be domiciled in part of the United Kingdom, Channel Islands, or the Isle of Man. The intended parents must be over 18 when the order is made. I know that the law commissions are looking at whether there should also be such a requirement in relation to a surrogate mother. So should the surrogate mother also be over 18? I don't believe that the law commissions are intending to make any recommendations in relation to the upper age limit, which is something else to think about. And then I come on the last two conditions are where most of the case law centres around, and it's where most of the issues arise. So I'll tell you sort of what the two conditions are, and then I'll sort of come on to talk about them in a little bit more detail, provided I still have time. The consent. So clearly this is one of the most important areas. The surrogate and her spouse, if she has one, must fully and freely consent to the order unless they can't be found or are incapable of giving consent. And the surrogate mother can't validly consent until the child is 6 weeks old. The last condition is payment. No more than reasonable expenses must have been paid, and the court must agree or authorize those payments retrospectively. So what are the issues which arise, the pitfalls that arise? First of all, as you can probably understand, surrogacy very often has an international element to it, and at least 90% of children from such arrangements are born overseas. Where a surrogate is in another country, then difficulties can arise and often arise when the intended parents come to bring the children back to the UK. So it is absolutely of utmost importance that they take both family law advice and immigration law advice to ensure that the child is not stranded in a foreign jurisdiction after it's born. There can also be problems which are connected with the surrogate. So we're looking at a surrogate changing her mind, there being no valid consent, and perhaps the surrogate can't even be found. If in that last case, if the surrogate can't be found, then the court does have the power to dispense with her consent. If the surrogate withdraws her consent, then the surrogate will remain the legal mother. And the father will either be her husband if she's married, or the genetic father if she is not married. The court will then have to determine the arrangements in accordance with our domestic legislation, which is the Children Act, and in those cases, again, the child's welfare will be paramount. We also have problems. The cases have also addressed problems where related to the intended parents, such as parents separating or one of the parties dying. But actually, that has been assisted by the change in the law, and the fact that parents can now apply as a single person has, to some extent, addressed some of those problems that have arisen. Finally, I'm just going to look at payments to the surrogate. Profit, and this is quite a controversial area, but profit making from surrogacy is prohibited. However, the intended parents can pay the surrogate mother for her reasonable expenses. So it won't surprise you that there have been many cases looking at what constitutes reasonable expenses. But when considering a parental order, the court must be satisfied that no money or other benefit other than for expenses reasonably incurred has been given or received by either of the applicants unless authorized by the court. So that is the bottom line. But in practice, of course, many, especially foreign surrogacy arrangements in America, do include a commercial element. And so, as I touched upon earlier, the difficulty facing the court is by the time the application for a parental order is made, the child is here, living with the intended parents, and refusing to make the order would therefore leave that child in a predicament of real need. So to some extent, the court's hands are tied, and when considering the child's welfare, it will feel compelled to make that order. How am I doing for time?
You're well, 5 more minutes.
Okay, so my last slide deals with the proposals for reform. So shall I hand... Go on there. Okay, so I mentioned in... yes, okay. Getting the green light. So the Law Commission of England and Wales and the Scottish Law Commission are jointly working on a report at the moment. The work started in May 2018. And as I said at the beginning, they are intending to produce a report with proposals for reform in 2021. And we discussed 400 pages, the recommendations are at the moment. So they are very detailed, and I can't even really sort of scrape the surface today. But some of the recommendations include that, in fact, there's a real emphasis that much of the work must be done before conception, because at the moment, so much is done after the child is born, and that brings with it many difficulties. So the more work that can be done in advance, the better. So before conception, the recommendation is that the surrogate and intended parents put in place a written surrogacy agreement, obtained independent legal advice, and had counselling. The surrogacy agreement should then be ratified by a regulated surrogacy organisation or a licensed fertility clinic. And the idea is that whereas now the surrogate has to provide consent after 6 weeks, so one can't apply for a parental order until those 6 weeks have passed, the idea now is that they won't need to apply for the court at all, provided certain requirements are fulfilled. But there will then be a period within which the surrogate can object. And if the surrogate makes an objection at that stage, within that sort of time period, then the intended parents would need to make an application to the court for a parental order. So there will be cases, or it is proposed that there will be cases where a parental order will still be necessary, and for example, that will apply if it is a foreign, if there is a foreign surrogate. But for many cases, domestic cases, they're provided various requirements are satisfied. The idea is that they won't have to apply to the court for an order in the same way as they have to at the moment. And I think I will stop there and then sort of get into it in a little bit more detail if we sort of have time at the end.
Thank you. Okay. Do you want to go ahead and?
Okay.
Yeah. Perhaps I'd like to. Oh, the microphone. Yeah. I'd just like 2 points to what Flora has said with regards to the Law Commission. So that the main purpose of the consultation of the Law Commission is to bring some consistency to the law, because the government has issued multiple policy documents with regards to surrogacy. They are internally inconsistent, so many people don't actually know where they stand. In particular, with regards to immigration, I deal with quite a lot of advisory work for surrogate parents, intended parents, and immigration nationality, because until a parental order is granted, the intended parents cannot bring the child into the UK unless the Home Office exercise their discretion to grant leave to enter into the UK. And how they exercise that discretion is, as it always is in the UK, very much a problematic area. Last year, so in 2018, the courts in the UK granted 400 parental orders. And that made it easier for children to come into the UK. But there are many thousands of kids outside the UK pending a decision from the Home Office as to immigration. So immigration is really...
And sometimes the parents are back here, so
Yeah.
the children are really left.
The children are left outside of the UK in temporary arrangements, which are obviously not in their best interests. And with regards to the right of the child to know its origins, the law in the UK currently says that a child is entitled to know non-identifying elements of its origins, and it is envisaged that the Law Commission may extend that. There is currently a case which I am doing, TT and YY, that has been widely reported in the media, that challenges the notion of a child needing to know the identity of the mother, or even needing to have a mother named in the birth certificate. My client is a transgender male who has given birth to a child, and the registrar wanted to register the child, the father, as mother, and he objected and brought a judicial review against that decision. And that decision will also have a knock-on effect on what happens with surrogate parents. We are arguing that the whole system needs to be overhauled, and parents registered in the birth certificate as parent 1 and parent 2, as in Canada and many other countries. And the figure of mother and father are too gendered for today's society. And that obviously will impact on intended parents, who quite often are same-sex intended parents in surrogacy arrangements. So, Jorge.
Okay, thank you. Buenos días. Good morning to everyone. Thank you for this kind and warm invitation to talk about surrogacy in my country. The name of my talk is, the title of my talk is Surrogacy in Spain, Reality versus Legality. I will explain why this dichotomy. Some minutes about historical context. The 1988 law about techniques of assisted reproduction was considered very liberal and pioneering in that time. It allowed assisted reproduction for single women and widows whose husbands had agreed to donate their sperm while living. But at the same time, in Spain, the Special Commission studying in vitro fecundation and artificial insemination was created, whose recommendations in the field of surrogacy were as follows. First, surrogacy must be prohibited in all circumstances. That was 30 years ago. Two, the individuals participating in a contract of surrogacy must be subjected to a penal sanction, as well as the agencies and the institutions favoring it. And three, the health centers or services in which these techniques take place will be subjected to a sanction. This is because our Article 221 of Spanish Penal Code states, it's very important to understand what I will explain later, those who through economic compensation deliver a child to another individual without the existence of a relation of parentage, eluding the legal procedures of custody, hosting, or adoption, with the objective of establishing an analogous relation to that of parentage, will be punished with imprisonment of a duration of from 1 to 5 years, and with a legal impediment to exercise parental authority, tutelage, or custody during a period going from 4 to 10 years. The same sanction will apply to the person who receives the child and the intermediary, even if the case of the delivery of the child took place in a foreign country. That was our situation 30 years ago. The next step is the 2003 law, which concluded the earlier law in various ways, for example, by allowing the use of cryopreserved pre-embryos, but this meant that there were two laws at the same time for the same purpose, although they were complementary, so it was reasonable that the two of them be merged into one, as we will see. At the same time, and it's essential for what we are going to talk about, in 2005, the law that allows gay marriages in my country was approved, and the homosexual community is who have really enhanced and developed the techniques of assisted reproduction, leading them to the attention of the average citizen. That was our framework or point of departure, and in 2006, our current law came into force, which is called Techniques of Assisted Human Reproduction, which annuls the two previous and complementary law, 1988 and 2003, and at the moment is the sole law in Spain which regulates this field. Let's go to the current legal frame. In 2006, the valid law states in its Article 10 the following, which is absolutely fundamental to understand what I will say later. Article 10, a contract convening the gestation, whether for profit or gratuitous, of a woman who will renounce to paternal parentage in favor of a co-contracting party or a third party will be null and void. Second, the parentage of the children born from surrogacy will be determined by childbirth. This is the legal situation today. This Article 10 is identical of Article 10 in the 1988 law. So between both laws, more than 18 years, the prohibition has no change in a single comma. Therefore, the inability of subrogation of the year 1988 was confirmed in 2006 in the same terms. 1988, we had a socialist government, same as in the year 2006, the same now. So, why have I called this talk legality versus reality? The reason has to do with the decision taken by an advisory body, Spanish body called Dirección General de Registros y del Notariado, more or less Directorate General for Registers and Notaries. The registered scheme filiation of children born from her mother must comply these requirements, and it's essential to understand what is happening in my country. These 5 requirements. 1, those countries, surrogacy must be permitted. 2nd, either the father or mother must be Spanish. 3rd, the procedure and the rights of the parties have been warranted, especially the rights of the pregnant mother. 4th, no infringement of the interest of the child. And 5th, the resolution of the country of origin must be executive or non-appealable. This resolution, called Instrucción Directive from October 2010 of that body, becomes essential to understand this text, because in these cases, children have access to the civil registry and are naturally Spaniards. We must say that Spanish couples have traveled to countries like Ukraine and Russia to hire surrogate mothers, but even more to India, where these contracts are cheaper. Wealthy couples travel to California, Boston, Wisconsin. This is why I have called this talk legality versus reality, because on the one hand, we have legality contained in our 2006 law, which clearly prohibits subrogation, and on the other hand, reality that allows this practice. So it is very important to highlight that in Spain, this situation has occurred through a great change in administrative channels, i.e., when the consular administrative body allowed the register of children born from surrogate mothers with no opposition from the public prosecutor. This meant that the door was being opened to register these children who came to Spain with a Spanish passport. Therefore, legality was being overtaken by reality. This door was open until the sentence of the Supreme Court in February 2014, which I will talk about later. Sorry. If I have mentioned the 2005 law, which allowed gay marriages, it is only because that fact has helped greatly to open that door officially in favor of these children. Also, I have to say that the fact that some very famous people in Spain have applied for surrogation, a very well-known baroness and several singers, has facilitated this recognition and also made them known to the public. In conclusion, what I mean is that gay couples have provided a great push towards the recognition of these children, finding alternative solutions in a prohibited law. Application started in the year 2006, officially, not before, and it is essential to mention a pioneering couple in Valencia, a gay male couple from Valencia who hired a surrogate mother in California. They had 2 children, and when they went to register them in the Spanish consulate in Los Angeles, the registration was rejected because of the Article 10 that I said before of the law 2006. Both parents appealed against this decision, and the Directorate General of Registries and Notaries resolved this matter in favor of the couple. Both children were legally registered based on Article 23 of the law of the Spanish Civil Registry. So, these children born from this gay couple are legitimate sons and Spaniards, and they have all rights provided. The hypocrisy was evident. These children have been born through a system that is legal in California, surrogacy, and have been recognized by a California resolution, and therefore their Spanish parents have only to register with a Spanish diplomatic official organ, observing the rules of the registration regulations. It means that there was no fraud, no forum shopping. If we add that this fact has no implications for the so-called Spanish public order, this registration is made to reach a desired goal by bypassing the existing ban on surrogates parents. It was in this moment, January 2010, when the public prosecutor starts acting. And by September of this 2010, the Court of First Instance in Valencia rejects the decision and unregisters as Spaniards the children of this gay couple. That decision was appealed, and a year later, in 2011, the Provincial Court of Valencia confirmed the prohibition, rejecting the inscription of these children as Spaniards. The couple, this couple from Valencia, also appeals against this sentence, and in February 2014, the Supreme Court, based in Madrid, has sentenced that the registration of these children must be forbidden. These are some of the reasons. The principle of legality, because as we have already heard, Article 10 of the Law 2006 prohibits surrogacy, and surrogacy infringes upon Spanish international public order based on our constitutional principles. This sentence has been dictated in what we call plenum or plenary of the civil chamber of the Supreme Court, chamber number 1, composed of 9 judges. But we must also say that 4 of them are in disagreement with this. That's why the sentence denying surrogacy has thrived in extremis, it means in the last minute, showing the great division in the Spanish society with regards to this extraordinarily sensitive subject. I'm finishing, 2 minutes more. I also want to indicate that the Indian Parliament passed a law in August 2013 in which essentially it was said that surrogate contracts will be prohibited between people from countries where surrogacy was prohibited by the law, like Spain. So nowadays, Spanish citizens with fewer economic resources cannot hire the gestation of their children in India. That's why, unfortunately, dozens of couples are going to Ukraine and other places where the Article 10 that I said before is not accomplished. Just finish. the legal situation since the sentence of the Supreme Court. Now we can understand more clearly why I have chosen this title to my talk, Surrogacy, Reality and Legality. There was a dichotomy because the law prohibited the surrogacy, but the register permitted the inscription if you accomplish these 5 requirements that I said before. Finally, the latest development, fortunately, I have to repeat 1,000 times, fortunately, is the sentence of the Human Rights Court in Strasbourg, June 2014, resolving the cases Ménesson and Lavassé, 2 cases against France, and these resolutions are in force in all European community. And for that reason, we can again inscribe our children born by surrogacy, always accomplishing, of course, the Article 10 said before. Therefore, the name of my talk, Surrogacy in Spain, Reality versus Legality, is still true without modifications nowadays. That's all. Thank you.
So time for questions.
I've got a question for Flora, actually. That in a situation where the surrogate mother withdraws her consent, so you've got the intended parents, let's say the father is the biological contributor to the child with the surrogate mother. If they've withdrawn their consent, what happens in terms of any liability the father has? Does he have to pay maintenance payments to the...
Oh, that's an interesting question. If he
So well, it depends on whether the surrogate mother is married
married or not.
or not.
So if she's not married, for instance?
If she's not married, then
And the intended father is the biological father.
Because you have a
Then-
situation surely where he and his wife or partner don't get the child, but
He will be legally responsible
Yeah.
for the child.
responsible for bringing the child.
Yeah.
yes,
So quite risky then, essentially.
it is
Yeah.
very risky.
And I was thinking that because you were saying that there are situations with immigration that are difficult where, for instance, the child is being brought up. Chances are that as time goes on, if the surrogate mother is looking after the child, she might be more likely to withdraw consent. If, for instance, the immigration situation isn't resolved, child gets to be 1, 2, 3, surrogate mother's bringing her up abroad.
It's quite rare for that to happen. So
Is it?
normally they arrange for a family member or somebody else to be with the child abroad.
Or they would be abroad themselves.
Or
It's
they are
only
abroad themselves, yeah.
Thank you.
But yes,
I just wanted to say one last thing in terms of these the Law Commission proposals. Thank you, Jorge. That the whole project doesn't, and we talked about this previously, doesn't actually seek to examine whether or not surrogacy should be allowed. So it takes as its starting point that surrogacy is an accepted form of building a family, and therefore the proposals will not sort of deal with a lot of argument that is out there in any detail. They will simply look at how it can be sort of much better regulated going forward. Over to Brexit.
no? I think, is there a coffee break before Brexit? Yes. Y el desmono están registrando los niños. ¿Y van a cambiar la ley? O sea, deja a los niños sin protección.
Hello, thank you. I was thinking, what happens if it goes wrong? Yes. So how can you? I do. Let me give you my card first of all, and then can you send my WhatsApp or that's easier? That is my mobile on there. Let let me give one to your father as well? That would be amazing, and then I can put it on my...
Thank you.
Right,
Luego te lo mando por correo si te interesa. Sí, es que me ha interesado mucho lo que ha dicho. Porque voy a... Bueno, estamos mirando un poco... Tengo una reunión con la Comisión que está toda la ley y bueno, ver también cómo se está en España de mal. Te mando correo con el informe de la Comisión para que lo veas también. Oye, tengo que enchufar esto en algún lado, porque tengo aquí las preguntas del Brexit y si sé que no hay enchufes.
Thank you, Carly.
Well done.
Thank you, sweetie.
Great team.
Well, very good team.
Yeah, that was brilliant.
We can repeat it.
And it's going to be live streamed.
You think so?
I don't know. Is it? Are you trying to look for? Yeah.
Miriam, aquí hay...
Han inventado esa regleta y no funciona.
¿No? ¿Quieres mi cargador? A ver. ¿Qué se puede desenchufar?
A ver, aquí algo podemos hacer. Han inventado la regleta. Si ya hemos sacado uno, vamos a sacar dos. Ya está. ¿Sí? Aquí no es el que alguien lo quise. Sí, porque estoy a 15 y se me olvidó ponerlo ayer por la noche. Hombre, me imaginé que había aquí...
Ya.
400 inscritos.
Ah, el bolso, digo. Sí, 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 fenomenal. Yo estoy haciendo cada vez más trabajo de esto, vamos. Y bueno, hago todo tipo de extranjería, manualidades, humanos.
Uy, qué bien. Ah, pues bueno saberlo. Pero estás allí, ¿no? No vienes.
Yo estoy allí. Yo estoy allí.
Vives allí.
Yo soy abogada inglesa. Yo no soy abogada rural. Yo me hice abogada allí.
Claro. Estudiaste allí la
Estudié allí la carrera y... O sea, yo estudié una carrera primero aquí y luego me fui allí y estudié otra.
Quería estudiar en Inglaterra.
No sé si lo habrá dejado. No lo sé, es que no se puede meter Marfil.
Robert. What do I say about you? Mariana, a ti no te voy a presentar. No, no me gusta conocer. A ver, me da Okay. Is that it? Where is it? Yeah, okay. Brilliant.
Don't feel obliged to read all that.
No, I was just, yeah, I mean, we don't have a lot of time anyway. Ah, mi ordenador, perdón. Yep. You each have about 10 minutes.
Oh, we have 10 minutes.
Yes,
Okay.
I think at the beginning. Sorry, we're going to wait for Mariana. Ignacio, do you want to introduce yourself? I think we only have Ignacio, Rachel, and Antonio's. Oh, sorry, Robert, we don't know either. Maybe if you just do a brief introduction of who you are
Yes.
whilst we wait. Yeah?
No?
Go ahead, yes.
Okay, so my name is Robert Watson. I'm a partner in tax dispute resolution at the firm